I think we can get started as people slowly join. So I first want to thank everyone who has come here today and who has shown up to watch. It was really amazing to see how many people signed up. And I think it's really important that we are having this meeting. I think one of the strategies of this whole thing has been to drag it out for so long and to make it so technically complex that people have had no option but to disengage. And I think it's really important that as things are now speeding towards closure, that we are coming together and we are sitting here to understand this now. So into the September of 2020, the Commission released its proposal for a new pact on migration and asylum, which consisted of 5 key files. So the screening regulation, the asylum procedures regulation, the regulation on asylum and migration management, the crisis regulation, and the Juridical regulation. And we released our first policy analysis as BVMN that basically called this a failed repackaging of the hotspots approach. But what we're seeing now is something that's actually even worse. In March 2023, the Parliament adopted their position, which did not go far enough in protecting the fundamental rights of people on the move, and basically legislated for or set the stage for a system of mass detention for people from the age of 12, children from the age of 12 years old, accelerated procedures at the border, and rapid returns. There are 2 files that we won't be discussing in detail here today because we don't have time to discuss them all. And that will be the regulation on asylum and migration management and the Juridical regulation. The regulation on asylum and migration management is essentially a repackaging of the Dublin system, which is where people are supposed to claim asylum in the first member state that they enter, which they can. But essentially, this leads to an overwhelm in the system in the frontline member states and the northern member states not taking enough responsibility for redistributing those claims. And this file was supposed to address this crisis and to increase solidarity between member states. But as it stands in the file, whilst member states can opt to take on people and process their claims from frontline member states, they can also choose to give financial aid in order not to do so. So one way they can do this is they can give funding to the frontline member states for capacity building, which will essentially mean money for the construction of prisons and offences, or they can give money to third countries in order to curtail migration in the first place, which is another step towards border externalization. The Juridical regulation is also very concerning. This is the system whereby people are fingerprinted when they enter into an EU member state. So it's easier to see which states they have been in first to facilitate their return. And at the moment, it's just fingerprints that can be taken. But in the new regulation, they're looking to include facial images as well, so that people can be searched through facial recognition technology, which is historically known to be filled with racial bias. There will also be access for law enforcement authorities, which represents a dangerous overlap between immigration, administrative law, and criminal law for people who have not committed any crimes. And lastly, the threshold for fingerprinting will be lowered to the age of 6 years old. So all this data can be collected of people of children from age 6 upwards. So the ones that we will be going into here today is the screening regulation, the asylum procedures regulation, and the crisis regulation. And I will just briefly touch on each one and how they will work together. And then we have experts from countries where these things have already been piloted. So from Greece, from Italy, from Turkey, and from Poland, who will go into the details of each one. But basically how it's set to look is that every new person in a frontline member state will enter into a screening centre, which will be placed near or at the external border for a 5-day screening process that will determine whether or not they have valid asylum claims. Those who have valid claims will then go into those who have what are deemed as claims will go into normal procedures, and those who are deemed bogus asylum seekers will be funneled into border procedures. A particularly concerning aspect is that these centres are deemed as not being on the territory of the member state. So through something we call the legal fiction of non-entry, places where people are held in screening centres are not seen as being on the territory, which also is very dangerous for the protection of their fundamental rights, as they are considered as not having yet entered the EU. So if you consider, for example, the closed controlled access centre on Samos, this will no longer be considered as a place that is on EU territory. So from there, people will be funneled, if they are not deemed as having valid claims, into fast-track accelerated border procedures, again at the border, which will last 12 weeks. So, and this applies to all children, also from the age of 12 and upwards. So we're looking at children being detained for 3 months or more in reality, just for the assessment of their claim. The 12-week period is also probably, I mean, we would say it's not enough for a full individualized assessment of people's claims. And at the moment, it's not even decided whether people will have access to free legal aid whilst they're in these border procedures. Then in the asylum procedures regulation as well, they are strengthening the safe third country principle. So this is a principle that says if you have transited through a safe country, then you can be returned to that country and they should process your claim. And we've seen this happening, for example, as we'll go into later, in Turkey. At the moment, only 6 of the 27 member states use this principle, but the asylum procedures regulation wants to make an EU-wide list, which would allow all the other member states to circumvent national debates on the topic and to implement the procedure. So basically, people will go into screening. If they've been through a safe third country, they can then go into accelerated border procedures and then directly be returned to that country. And also a lot of the Western Balkan states will count as safe third countries as well, which many, many people transit through to reach Northern Europe. It's also under doubt whether the suspensive effect of appeal will apply. So this means that if you appeal the decision, you should not be removed from the country until your appeal has gone through. But they're seeking to remove this and essentially to be able to remove people to other countries, even once the appeal has not gone through, which would deem that they would be safe to be returned to that country. So essentially what we're seeing is a prolongation and a legalization of the pushback practice. Then we come to the instrumentalization regulation, which we can see in past events in Europe. If we look at Greece, Turkey in 2020, Spain, Morocco in 2021, and most recently Poland, Latvia, and Lithuania with Belarus. And right now we see this ongoing with Finland. So this is when a member state can say that a third state is weaponizing or instrumentalizing people on the move and pushing them into an EU member state. And when this is happening, they don't have to apply basically any procedures. People don't have to have access to asylum and can be directly put back in the third country. So this basically represents the immediate legalization of pushbacks in these crisis situations. So I don't think it's too much to say that what we're moving towards is the abolition of the right to asylum. These are political decisions that are set to be closed on the 7th of December. It's been announced that all of the people working on all of the files from the council, from the commission, and from the parliament will all sit down in a room and make all of the political decisions on that day. Whilst we don't know if it will happen on that day, there is a move to close all of this before Christmas. And so what's really important is that this will be hailed as a breakthrough, as a new way of managing asylum. And what we have to make sure is that we don't stay silent and that we call this for what it really is. And that's why we're having this webinar here today, to explain what it will look like and why we need to say something about it. So I will first pass to the situation of the screening regulation in Greece, where we will have Minos Mousarakis, who is a lawyer registered at the Athens Bar Association and working as a legal and advocacy officer at Refugee Support Aegean, which is a Greek non-profit organization providing free legal assistance to refugees. He's previously worked at the European Council of Refugees and Exiles on the reform and implementation of the Common European Asylum System. Minos holds a master's in refugee and forced migration studies from the University of Oxford and law degrees from University College London and Marseille University, and has conducted research for the European Parliament, UNHCR, and academia. Thanks, Minos.
Thank you very much indeed, Hope, and thanks to the Border Violence Monitoring Network for organizing this webinar, and to the fantastic over 200 people who have chosen to spend your afternoon and evening with us. This is absolutely stellar, even though the topic of discussion is both depressing and extremely worrying for what's to come in the next days and then the next years for the EU. As Hope mentioned, what I'll try to do is to have a closer look at the first piece of that extremely complicated puzzle, which is the screening regulation. Perhaps with a very short word of introduction, this reform is being presented even explicitly as a new pact, a new approach in how we deal with migration. I absolutely agree there's not much that is new about it. And crucially, that we're not legislating and debating asylum policy in a vacuum, as we're very often led to believe. There's already a very detailed, elaborate, also quite complex framework of EU rules on how to manage the arrival and protection needs of refugees. These have been built since the early 2000s. And what we've been seeing since 2016 is a very sustained effort at actually dismantling all of that, at lowering the level of protection that the EU offers to those that flee persecution and human rights violations. So when we look at something like screening, what is this about and what should we be expecting when it gets adopted? Screening is something that emerged with quite a bit of inspiration from Greece and from what we call in our domestic system, the reception and identification procedure. This is a process and a framework that has existed in Greece for quite some time. We legislated this 12 years ago, back in 2011. The idea being that there needs to be a specific process to identify every person who arrives irregularly on the national territory before we do anything else. Now, to my understanding, there's a lot that's been presented in terms of screening as a completely new thing that did not exist in the EU realm. This is not necessarily the reality. There seems to be more of a symbolic appeal of the reform because actually all of the aspects of what's in the screening proposal are things that actually already exist in the asylum framework, in the asylum rules. So things like identifying people, determining their nationality, fingerprinting them for the Juridical database that Hope mentioned, screening them for medical conditions and vulnerability, and then channeling them to asylum procedures. All of that pre-exists this reform. It's already in force and it exists as EU law that member states need to apply. What we actually will end up with is a very perverse effect where once this regulation gets adopted and becomes binding law for all 27 EU member states, we will actually have more obstructed a way of access to asylum procedures than what we have at the moment. One of the things that the screening regulation puts forward is that people who make an asylum application, so who express the intention to seek asylum, are, and of course should be considered asylum seekers. So they should have all of the rights that are bestowed upon people who apply for asylum, who require protection until a decision is made on their claim. However, their registration as asylum seekers will not take place until the entire screening process is completed. Now, what this actually gives is, in view of severe delays, chronic gaps in capacity on the part, for instance, of Greek authorities to conduct screening, this will lead to a very significant time lag from the moment where people make the claim for international protection and the moment they're actually registered. Due to this, it will be impossible for people to be able to prove before authorities that they are asylum seekers, that they should not be detained, removed from territory, or access key services, very often as crucial as getting legal assistance, authorizing a legal representative, if they have not demonstrated that they have the status of an applicant for asylum. Another perverse effect to be expected is that we are extremely likely to end up with one authority that conducts screening and a different authority that is in charge of the asylum process. This is the way it happens in Greece. We have a reception service for screening and an asylum service for determining asylum claims. Very often, these two fail to coordinate and collaborate properly. This leads to asylum authorities very often unfairly dismissing asylum applications, disregarding the conditions, the medical needs, the vulnerabilities, the past trauma experienced by people before them, and invoking the existence of this screening process to say that this is a matter for a different authority to deal with. Another aspect that very often stems from Greek practice and has been amply documented is non-compliance with the letter of the law. And this is rather regrettably to be expected also at EU level once we have a screening regulation. There will be lots of different obligations and steps in the process. They're not necessarily going to be respected in practice at the external borders of the EU. What we see in Greece is that the authorities that are in charge of screening systematically and almost always conclude that the screening process has been conducted, but forego crucial stages thereof, namely medical checks and assessing the vulnerability of people that undergo screening. This means that in the eyes of the process, people have gone through screening. Very often they have never been examined by a doctor, by a psychologist. Any claims they've put forward in terms of past torture, risks of trafficking have never been recorded, and they're then funneled into asylum procedures that are bound to be inadequate and unfair to actually meet their needs. Now, if this were to be properly conducted, you can imagine this requires substantial resources, and in member states such as Greece that lack those resources systematically, despite generous and very consistent financial investments on the part of the EU, this would lead to humongous delays in practice. And again, very often people would stay in a stage of screening, in de facto deprivation of liberty, in those screening centers, be it at borders or elsewhere, awaiting the conduct of a process that national authorities are not equipped to properly do. Hope also mentioned the so-called fiction of non-entry, this legal, extremely controversial tool that would have member states have people on their soil in mass detention, but treat them as not having entered the territory. From a spatial perspective, there's nothing that changes. People would still be on a Greek island near a Polish town or train station. Only in the eyes of EU law, they would consider to be outside of EU territory. What this would permit would be for member states to have a sort of semi-legitimate legal tool, but mainly political grounds, to keep people completely alienated and isolated from local communities, and in a state of detention that would clearly deprive their fundamental right to liberty. For Greece, this would be a game changer. This is relatively familiar for countries that use very small-scale border procedures, for instance, at airports, though again with very significant legal considerations, as is the case in France, in Germany, in Belgium, Switzerland. It's not something that has been tested thus far in Greece, where we have tens of thousands of people going through these screening procedures on the Greek islands and at the Greek land border. And this would have a very substantial impact in practice with mass detention in border camps, which has not only huge human costs, unimaginable ones, but also very, very onerous financial and operational costs for the member state, to the point where it would probably become an unfeasible option. That said, and even though this has been a core concern from civil society from the get-go, from the moment we were presented with a screening regulation, we have yet to hear a convincing alternative on the part of the Commission and the Council on how any of this can actually work without detention. The very final point, which I think has again been a very significant battling ground, not only between the co-legislators, but also in civil society at large, is the so-called monitoring mechanism that has been put forward for the screening regulation. The Commission has suggested this as a way to respond to mounting criticism relating to non-compliance with fundamental human rights standards in the EU, mass pushbacks, extremely violent, brutal tactics at different borders throughout the continent. In very practical terms, not only is the mechanism proposed for screening not related to pushbacks, because screening would virtually take place at a much later stage when the person has already entered a procedure. So the most difficult part would be probably over for them. But also there seems to be a lot of contention between Council and Parliament of the scope of that mechanism, the powers thereof, and also whether member states could incorporate this within existing state authorities and avoid creating new mechanisms. We're yet to see how all of this is going to play out by December, but we expect this not to be a very convincing plan to deal with pushbacks. I'll leave it at that. Looking forward to the questions and Q&A. Thanks very much again.
Thanks, Minos. And yeah, good reminder for everyone. There is a Q&A function in the chat, and we will have time at the end. So please do write your questions as and when they come to you. We now understand what screening will look like for people who enter the member state. So for the next step, we will go into what the asylum procedures themselves will look like once people pass through screening. And for that, we turn to Eleonora Celoria, who is an Italian lawyer and member of the Association for Juridical Studies on Immigration, or ASGI. She's completing a PhD on immigration law at the University of Turin, and she is currently working as affiliate researcher at FIERI, the Forum on International and European Research on Immigration. Her research focuses on administrative detention and its implementation at European borders. Thanks, Eleonora.
Thank you very much, Hope, and thanks to the board for organizing this webinar. So I will go straight to the point, the asylum border procedure. First of all, please note that I will only focus on this new regime, this new border regime, and not on the entire amendments made to the current asylum procedure directive. As Hope said already, there are many changes to this directive that will be turned into a regulation. And those changes will basically lower the level of protection and the procedural guarantees for asylum seekers. So with this framework in mind, let's focus on this new border procedure. So basically, what the EU legislator wants to do is to turn what so far has been the exception into the rule. So far as you know, most of the asylum applications are normally carried out in the territory, within the territory of a member state, maybe with some changes with regard to Italy and Greece after the adoption of the hotspot approach. But the main rule is still that asylum seekers are into the territory. And they are accommodating according to member state reception system. Also, as you probably know, the Court of Justice some years ago stated very clearly that border procedures are exceptional and people can be kept at the border only for a very short period of time. And this basically will change if the asylum procedure regulation is adopted. So I will focus quite briefly on the some of the changes, some of the procedural rules, but especially on the implication of this new regime. So applications will not be carried out within the territory, but at the border, or at least under this border procedure, while people will be most likely detained. And I will come back on this point. Also, as Hope already anticipated, people will have to spend time at the border. Well, they can be kept at the border for up to 12 weeks, including the appeal phase, in theory, because in practice, this will never happen, I think, at least as far as Italy is concerned. But these 12 weeks can be even extended up to 16 weeks in situation of crisis. And as for the people who can be involved into this procedure, we find basically everyone who underwent a screening procedure. So as Minos explained, from the screening, people can be channeled directly into an asylum border procedure. And these include families with children older than 12 years old, and in specific cases, even unaccompanied minors. And it is quite likely that the reform will make it mandatory to apply a border procedure in some cases. and namely when the applicant is considered to be a risk to national security or public order, when the application can be considered fraudulent, the applicant presented false information or documents, and most importantly, and this is the most concerning part, when the applicant comes from a country for which the protection rate is 20% or below. So basically this opens up spaces for racialization of the asylum system. As applicants from certain countries will have, as a rule, less guarantees. And so there will be a discrimination basically based only on their nationality. Then, as we already heard from Hope and Minos, one of the most critical aspects of the entire seamless procedure, as it was called by the Commission, so this new border regime, is that applicants are not authorized to enter the territory. And it seems to, basically to all of us, quite clear that in order to enforce this provision, member states will have to systematically detain applicants involved in this asylum border procedure. We have seen that in the new regulation, the rules on detention will not be substantially changed. So basically what we already have ground for detention that allow for the detention of asylum seeker in order to decide upon his or her right to access the territory. And most likely, member states will apply this ground in order to detain people at the border during the entire procedure. For this reason, many academics and NGOs, of course, pointed out to the risk of a system based on a generalized detention, which has a huge impact, as we know, on the right to liberty. Also, another critical point relates to the places, the locations where such procedure can be carried out. According to the proposal, detention/accommodation, but most likely detention centers, should be at the proximity of borders. But if the capacity of these centers is not sufficient, member states can carry out these procedures elsewhere on the territory. For instance, in the case of Italy, we already saw that the capacity at the border is not enough, so they are trying to move people within the territory. But here, the situation becomes quite absurd, because basically asylum applicants are inside the territory. They might be kept close to big cities, for example, but they are not authorized to be inside, meaning that most likely they will not be issued cards or permit to stay, and I guess they will not be allowed to freely move on the territory. And this is where I guess this is one of the main concerns raised by this reform. Basically, we will have asylum seekers who are more isolated, more precarious, more vulnerable, and less integrated into the territory. And of course, they will have a huge impact on their fundamental rights, not just the right to liberty, but think also to the right to defense, have access to legal assistance, but also the right to health, for example, because if they are kept at the border or in closed facilities, they will not have access to doctors or psychologists, for example. But on the other hand, I guess this will have quite a critical impact on the communities, because at the end of this long asylum and eventually return, and I will get back on this point, at the end of this long procedure, migrants will not have any ties with the country. They were kept in while being formally excluded from. So also in terms of the relationship between asylum seekers, migrants, and the community, this will have a devastating impact. As I said, another element of this new border procedure is the strong link between the asylum procedure and the return procedure. Again, a border return procedure. Basically, what the Commission envisaged is that immediately after the asylum procedure, if the application is rejected, a return procedure will start. And the rationale, the idea is that in this way, we will be able to return immediately, basically rejected asylum seekers. But here the assumption is basically wrong. All the data, I was looking at the data, especially in Italy and in Greece, and it's very clear that the return rates did not increase in recent years when we saw an increase in detention rates. So I don't have time to show you the chart, but I can share later the data with you. And it's especially in 2018 and 19, we saw that detention rates increase, especially in Greece, and then at the same time, returns rate completely decreased. So there is no link between keeping people at the border and the effectivity of returns. And so, yeah, actually, what this entire procedure will lead to is that if the asylum application is rejected and migrants, as it happens in most cases, cannot be returned, because as you know, returns are mainly linked with the cooperation upon the country of origin. And if there is no cooperation, there is no return. So at the end of this very long and harmful procedure, there will be more irregular migrants in member states, and most likely an increase in secondary movements, because as I said, there's been less integration of these people, asylum seekers, into the country. And another element is that most likely those people will be more vulnerable to both abuse and exploitation. And so the picture is very, very critical. What happened, very briefly, I will touch upon what is the situation in Italy, because I think this gives us quite interesting food for thoughts, at least when we look at this new border procedure, which imply detention. So basically, this plan of reducing guarantees for asylum seekers, limiting integration services, expanding the scope of accelerated procedures, it was implemented by the Italian government in 2023. And among these changes, we also, the government also introduced a new border procedure during which applicants are detained. So very similar to the proposal, to the Pact proposal. But if we look at what happened in Italy, we might this might give us a little hope, possibly, because the 2023 reform, as I said, introduced this procedure which allows for the detention of asylum seekers in order to decide upon the right to enter into the territory. This is applied to two categories of asylum seekers, only when the application is made at the border by a person who evaded the border controls, basically, which is quite similar to one of the provisions of the proposal of the screening and then the asylum procedure. And second, when the person comes from a safe country of origin. And again, here the rationale is not far from the idea of a mandatory asylum procedure for those who come from a country with a 20% recognition rate, less than 20% recognition rate. And finally, the law specifies that asylum seekers are to be detained unless they can submit a passport or provide a financial guarantee. And starting from September 2023, the Italian authorities extensively relied on this new border procedure to detain especially Tunisian citizens. So again, the racialization of the asylum system. But actually, in September and October, some courts issued a series of rulings in which they annulled the detention orders because they said they were in conflict with some very clear principles of EU law. Of course, Italian judges relied upon the current directive, but they mentioned not just the articles of the directives, but the EU law principles. And they are principle of proportionality of detention, of necessity, the need to carry out a case-by-case assessment of the situation, the fact that detention cannot be automatic and has to be an exception. So based on those principles, the judges ruled that this new border procedure is unlawful. These decisions, I think, are important because also when we look at this new pact, because no matter if these proposals will be adopted, these principles rest. They cannot be cancelled. They cannot be erased for our legal framework. And as the Italian judges did, I guess also we as lawyers and civil society have to remind both the EU legislator and member states that fundamental rights, including the right to liberty, including the right to asylum, which are enshrined also in the EU Charter of Fundamental Rights, cannot be set aside. And I stop now. And if you have any questions, I will be happy to get back on this asylum border procedure later. Thank you.
Thanks a lot, Eleonora. So this is kind of explaining how the border procedures will work, what they will look like, and how they've already looked in Italy. But something that we also have both mentioned is the safe third country principle and the way that this will be expanded. And one really good case study for this is to look at the situation with the EU-Turkey agreement. So I will now turn to Dr. Javedan Soykan, who is an honorary fellow at the School of Social, Political and Global Studies in the University of Keele, UK. Thanks, Javedan.
Hi, everybody, and thanks for inviting me to this really interesting and very important panel, especially in terms of migrants and people's migrants' rights and the rights of people on the move. Last summer, I can say last summer, like this year, I reviewed a Medical International expert opinion written by Anina Molis. You can find it online on the website of the Medical International. So my presentation will be based on this report and the findings. I also helped the author, Anina, to conduct some of the interviews and engage with the grassroots movement in Turkey and the NGOs, because there's a big difference what's written on paper in law and what's going on the ground in Turkey. Maybe the first thing I should mention that Turkish law itself has the concept of safe third country and the first country of asylum. And we adopted these concepts from the EU acquis, because Turkey is a candidate country to the EU for years and years. And this law, I used to call it new law, but now it has been 10 years old. And and it has been applied for 10 years. And we have been using this concept of third country, safe third country, for 10 years. In the Turkish case, maybe I can tell first what the concept is, and then how it is in the European Union Asylum Procedure Directive, and what's going to be changing and what's on the ground happening here. The safe third country concept is an essential part of the new Pact. And it means that it allows states to find people's asylum applications claims, those of whom are coming from a safe, so-called safe country that is deemed safe, inadmissible. What it means that, for the EU, there is this for the EU directive, there is this criteria I will mention now. But for member states, this might change. Maybe we can, in the Q&A, we can discuss about this with Minos, because I know what's going on in Greece, for example. While writing this report, we looked at this joint ministerial decision that which country is considered safe by Greece, and those people coming from those countries, applications rejected directly. So according to the Article 38 of the EU's Asylum Procedures Directive, actually it's a good definition, I can say, in terms of law, but not like as a human rights defender. So where an applicant will be treated based on this concept is the applicant can be sent back to a safe third country if that country is where this principle can be applied is life and liberty are not threatened on account of race, religion, nationality, membership of a particular social group or political opinion. You might be familiarized with these criteria because this is coming from the 1951 Geneva Convention's definition, actually. And the second one is there is no risk of serious harm defined in the qualification directive. This is also coming from the International Human Rights Law, Article 3 of, for example, Convention Against Torture or the UN Convention, or both UN Convention and the Council of Europe Convention. CAT, I mean. And then the third one is the principle of non-refoulement. This is actually, even if a country is not party to the 1951 Geneva Convention, this is customary part of the customary international law that no one can be sent to his or her life will be in danger under threat. So this is a really important part of international human rights law. And the next one is the prohibition of removal in violation of rights to freedom from torture, cruel, inhuman, or degrading treatment, as laid down in international law. Again, the possibility exists to request refugee status if found to be refugee to receive protection in accordance with the Refugee Convention. So this is the EU procedure directives criteria that a country can be deemed safe as a safe third country according to this criteria. But if we look at the Turkish case, this criteria is not applicable to Turkish case, and it was not applicable when the 2016 EU-Turkey agreement was made, and also the implementation of the returns based on the agreement was not lawful. Because first of all, Turkey has a geographical limitation to the 1951 Refugee Convention. When I started writing on this agreement 2016, and I also participated into discussions with the Council and the Commission bureaucrats when they prepared this EU-Turkey agreement in 2016 March. I was in Brussels, and we were discussing these issues that this criteria is not matching with what Turkey's asylum system provides to its applicants, because a non-EU national comes to Turkey can be registered and maybe protected according to non-refoulement principle, but cannot receive refugee status. You can only have a temporary protection. It's called conditional refugee status, and it's not even given on paper to anybody. So you are only protected against refoulement. You won't be sent back to your country of origin, but other than that, your rights, your rights are not guaranteed according to the 1951 Geneva Convention. But the situation deteriorated since 2016, so that when we come to 2023, especially after the last elections, general elections, and the presidential elections we had in May this year, the situation on the ground deteriorated a lot. There is so much hatred against refugees, migrants, and since the beginning of this year, registration is completely closed. There is no registration, I can say, in each city for an asylum seeker. And also Turkey is unlawfully deporting or returning, maybe we can say, people to Afghanistan, to the Taliban regime, and also to Syria. This is documented by Human Rights Watch or Amnesty International and other international NGOs, human rights NGOs, that we also mentioned in this report, Medical International Expert Opinion, why Turkey cannot be considered a safe third country. First, as I mentioned, even Turkey does not provide the refugee protection based on the 1951 Refugee Convention criteria. It has to be, it has to comply with the non-refoulement principle, which is also, part of customary international law, and also because Turkey is part of so many international UN conventions, and each of them bans torture. And in this principle, non-refoulement principle, actually comes from the torture ban. So just because of that, Turkey cannot send back a Syrian or an Afghan national to his or her country of origin. But Turkey has been doing this for years and years. For Syrians, the system, I can say, changed after the failed coup attempt of 2016. Maybe we can start it with the EU-Turkey, even EU-Turkey agreements, readmission agreements. And also for the Afghans, the Taliban regime, for men, male applicants can never be registered within the system for the past 3 to 4 years. But the forced returns, I can call them forced returns or illegal deportations, are taking place for the past 2 years. And it's open, obvious, if you go to the website of the migration presidency. Its name just changed a year ago. It used to be called the Director General of Migration Management, but you can go to the website and you can go to its X Twitter account, and then they publish daily, weekly deportation numbers, return numbers, and they are very proud of this. Like, we are protecting our borders, we are spending this much money to send people back. They are not talking about protection at all, and it's called, this law is called international. This law also is about international protection, but the presidency is not talking about protection at all. It's only protecting. It's only talking about security border management, returns, and deportations. And in Turkish, they don't even use the term deportation because there is no due process. There is no right to appeal, or actually there is no deportation decision. I can say that. Like, I'm helping people in detention, and they cannot access the legal aid, first of all, because their communication completely cut out with the outside world. If by chance you know someone inside and that person can reach you, an NGO, then we can help them. Like right now, I'm trying to help an Afghan female detained, someone in the west near Izmir. But I'm really having difficulty to find a legal, find a lawyer who can reach her and provide legal aid, because you need to know the person's all the details, the name and the surname and everything, the age. Like, they ask you so many questions, so you can enter the detention center and provide legal aid to that person. Otherwise, there are so many threats that, like, up to 6 months there is this detention period, but like the authorities are threatening people that you can stay here up to a year or more than a year, which is a lie, and then you won't be never out. So you have to sign these voluntary return papers. So people don't know, and there is no translation. There is no help with the language. So people usually, especially in the case of Afghans and some of the Syrians, they sign the papers, and they are actually, we Turkish people believe that they are voluntarily returned to their country, but actually they are forcefully removed from Turkish territory. So if we go back to the agreement actually worked maybe at the beginning, initially stopped the flow to Greece, but as the other colleagues mentioned, that it's only it only stopped maybe the rate of crossings, or the number of crossings, or it changed actually the system. Like here, we can still observe that there are crossings and accidents. Just we had the Pilos accident last summer near Greece, and it changed the routes. For example, like now from Libya or Cyprus, we know that human smugglers, migrant smugglers, are taking people rather than Turkey. Or it's not exaggerated, sorry, it's sorry, it's the number of pushbacks actually raised due to the agreement at the conditions within Turkey. People do not want to stay in a country like this when their rights are not protected, and there is an obvious risk of being deported or forcefully removed to not a safe country. Therefore, because of this reason, we cannot call also the Turkey as a safe third country. So while living in this situation, and also the economic crisis now we are having, the inflation rate like over 100, I can say, like they are changing the numbers, statistics, official statistics, but this is one of the reasons why people are leaving Turkey. As far as I know from the field, especially people in the Balkans are telling this truth. They cannot live in Turkey anymore with this economic situation. Even Turkish people are using the Balkan route to seek asylum in Europe. So with these conditions, people keep living and leaving Turkey either way, either the land border or the through the sea crossings with Greece. So maybe, as I said, the agreement worked at the very beginning, but I think it created this threat that people knew that they would stuck in those hotspots in Greece. That's why they stopped for a while, and they did not want to leave for a while. But now we know that it continues, and it became like a political deal between the two countries, Greece and Turkey. And so we have many small crises between two countries. Like the 2020, we had this political one on the land border that Turkey threatened Greece, and the EU Commission and even the Council involved, and there were like violent pushbacks and deaths at the border area. And just maybe I can little mention about the numbers, because based on the free admission agreement, people who crossed through Turkey to Greece after the 20th of March 2016 would be returned. And there is this one-to-one scheme. So each Syrian returned from Greece, one Syrian from here to be relocated in a European Union member state. But like, if you look at the numbers, the relocation scheme did not work that much. For example, by the end of 2019, only 22,700 Syrians have been relocated in different member states. Member states were not willing to take more Syrian applicants. And also only 1,843 migrants returned to Turkey middle of 2019. This is the Greek source I'm referring. Maybe Minos might give the accurate number. So for Turkish case, the problem is, I'm finishing. For the Turkish case, the problem is people, when they are returned from Greece based on this concept, safe third country, saying that these people are coming from a safe country where they can get access to efficient protection, and sufficient protection based on the 1951 Refugee Convention, then they can seek asylum. They have right to seek asylum, or they have protection here. But right after this agreement, we had the state of emergency period for 2 years, and under this period, with decree laws, so many changes made into fundamental laws of Turkey, fundamental codes of, even criminal code, for example, of Turkey. So the Syrians protected according to a regulation, temporary protection regulation, and a change made into this regulation with a decree law by the president. So people's automatic access. So in the regulation, it said that people coming from the Syrian Arab Republic have directly access to temporary protection system. But this has been changed right after the agreement during the state of emergency period. So now there is no automatic access for Syrians. Even people are coming from the islands back, returned from the islands, they did not have this access to protection mechanism. So, and also the migration presidency does not publish any data, does not share data. So we don't know how many people, those who returned, were returned from Greece, could access the protection in Turkey. Or whether they are registered, or whether they are deported, or whether they are, forced to sign a voluntary return paper. And I will complete. So the new pact is, unfortunately, making this situation is even worse, because there is now this criteria that certain protection criteria can be applied for this third country concept, and it gives power to member states, which is very dangerous. This might be against the international refugee law, and there might be breaches of international human rights law based on the torture ban, or Article 3 of the European Convention on Human Rights. And maybe, yeah, I can finish with just one little thing.
We should really wrap
just
up.
Sorry,
speakers.
Yes, I'm just finishing. So what I was going to say, taking into consideration what's going on in Turkey and what happened with this readmission agreement, which is baseless. I could not mention about that. It was a bilateral agreement between Greece and Turkey, but it's suspended now by Turkey, and there are no returns as far as we know since 2020. Taking in this situation on the ground here as well, like we have many violations of migrants' rights, refugee rights. We can say that a country might look like very safe on paper, because our law is based on the EU acquis, and we adapted most of the concepts of the EU asylum regulations, like they are directly translated and made part of the Turkish national law. But when you look at the implementation, it's completely different, and that's the problem. Like, if the system changed, not the paper, not the law should only be changing. The implementation, who the people on the ground who are implementing those rules, whether they are trained in international human rights law, in refugee law, whether they know what they are doing, is really important. So there is this huge discrepancy between what's written in law and what's going on the ground in terms of people's rights who are seeking protection. Okay, sorry.
Thank you very much,
Thanks.
Jessica. Yeah, I think you've given us a very comprehensive understanding of why safe third countries aren't actually safe. In the asylum procedures regulation, they're still deciding how they will deem countries safe or not. And for some member states, they're pushing that it can just be if somebody transited through a country, then they can be
forgot to mention about that. Yeah, the transit one. Yeah. And Turkey is a transit country, unfortunately, for Greece, and also still people from east coming from Afghanistan and Syria. Yeah.
Thanks, Javadan. So I think this is all really important. It also applies to the Western Balkans. So the BVMN will have a paper coming out next week, which explains that dynamic even more. So you can keep your eyes out for that. With that, I'm going to pass on to Marta to talk about the instrumentalization regulation. And this is what happens when people in situations of crisis, when essentially it's said that third states are instrumentalizing people against the EU. Marta Gorczynska is a human rights lawyer working as the head of the migration department at the Helsinki Foundation for Human Rights in Warsaw. She provides legal aid to migrants, carries out strategic litigation, monitors the situation at the border and in detention facilities for migrants, and reports on human rights violations. She provides legal expertise for international organizations and European institutions, such as UNHCR, the EU Fundamental Rights Agency, and the European Parliament. She advocates for a human rights-based approach to migration and global responsibility sharing. She is also a PhD candidate at the University of Warsaw, focusing her academic research on access to asylum at the external European borders and externalization policies. Thanks, Marta.
Thank you very much, Hope, and thank you, BVMN, for organizing this event. I will try to be brief so we have enough time for the questions and the next part of our webinar. So I will be talking about the instrumentalization, which, as you know, was introduced as a concept in 2021. First, in response to the border crisis that we are seeing at the EU-Belarus border that's been ongoing since the mid-2021. And you might remember that in December 2021, there was the intervention of the European Commission imposing sanctions of some of the Belarusian airlines that were flying migrants to Belarus. And then the new legislation act was proposed. So the council decision on provisional emergency measures for the benefit of Latvia, Lithuania, and Poland. And this was supposed to be the response of the EU to this new phenomenon at its eastern border, where Belarus and then later on also Russia would invite or lure under the false promise of an easy passage to European Union, migrants, asylum seekers, especially those coming from destabilized countries such as Syria, Afghanistan, Somalia, flying them into Minsk and then encouraging or forcing them to cross the border to Poland. The response of the Polish but also Latvian and Lithuanian government was actually to implement pushback policy and to send people back to Belarus under the narrative of the so-called hybrid war conducted by the Belarus against the EU. And then immediately the European Commission proposed this new piece of legislation. The justification of this document that never entered into force, and I will mention why in a second, was that, and here I'm quoting the document, it said that the instrumentalization of migrants by Belarus has resulted in a grave situation for these people in the European Union Belarus border region. Belarus's actions have created a humanitarian crisis with a number of fatalities already confirmed. The primary responsibility for addressing this crisis lies with Belarus, but then also, it was mentioned in the document, the EU decided to have its own response and to provide assistance to those member states that were in the front line of the border crisis. So you can see that in the document, it was recognized by the EU that the situation that was orchestrated by Belarus created the humanitarian crisis, with those people on the move being in the middle of the crisis, suffering from hypothermia in the Poland's forests, from dehydration, not to mention lack of access to regular asylum proceedings. We can also read in the document, in this proposal, that according to the European Commission, it was fully consistent with the new Pact on Migration and Asylum adopted in September 2020, which was mentioned already by Hope and by other speakers, and the accompanying legislative proposals. So what was the logic of the whole proposal? The whole logic of the proposal was to derogate from some of the procedural guarantees for the applicants in a situation where we can say that other states, so the third state, in this case Belarus, is using people on the move, is using migrants to exert some political pressure on the EU. So it actually, in the proposal, it meant the extended time for registration of the asylum applications, admissibility procedures at the border, limited access to territory for the applicants. So all those measures that actually limited the rights of those trying to enter and seek asylum in Europe, rather than addressing the actual problem that lies behind instrumentalization, which are the foreign affairs of the EU, the external policies. So the only and luckily the core fundamental guarantee for those seeking asylum, so the non-refoulement principle, was to be maintained, was to be respected, which, as we were then commenting the act, was better than what was actually happening at the border. But still, the main flaw of this proposal was that it was actually like all the negative consequences of the instrumentalization were to be suffered by the applicants themselves, not by the instrumentalizing state. So as I mentioned, the proposal never came into force, and this was mainly because of the Poland's position on that. So Poland was in the opinion that the right to asylum should be suspended as such in this case of instrumentalization, and mainly for that reason, it was never enforced. But it returned to us in the new piece of legislation in December 2021. Again, it was announced that the proposal for the regulation of the European Parliament and the Council addressing situations of instrumentalization in the field of migration and asylum. So the regulation that it's like next to other pieces of legislation that were introduced in September 2020, and this is supposed to be something extra. What is important here, I think, is that, and it says a lot about this regulation, is that when you look at the ECRE policy papers, ECRE calls this regulation as, and I'm quoting here, the worst of a series of bad legislative proposals on asylum issued by the European Commission. And why is it so bad, and why ECRE is assessing it so negatively? So, like, when you look at the reasoning of the document, you can read that the reason behind it is the highly worrying phenomenon observed in the increasing role of state actors in artificially creating and facilitating irregular migration, using migratory flows as a tool for political purposes to destabilize the European Union and its member state. So this was the starting point to the whole justification of the document, and then you can read that that leaders of the EU are committed to continue countering the ongoing hybrid attack launched by the Belarusian regime at the EU border, that they are also recalled. That they recall the need to ensure effective returns and full implementation of readmission agreements, and for that reason, they feel that they see the need to amend the current legislation and introduce this new concept, instrumentalization of migration, that would allow member states to derogate from some of the guarantees for asylum seekers. And as a result, according to the European Commission, this might be the effective response to those attempts and effective measure against it. But then you have to look at the definition of the instrumentalization. For that, you would have to look at this proposal of the amended Schengen Border Code, and there you can read that the instrumentalization, what it means are the situations where irregular travel of third country nationals has been actively encouraged or facilitated by a third country onto its own territory to reach the external border of the member states. But it can also refer to the active encouragement or facilitation of irregular travel of third country nationals who are already present in that third country. It can also mean, according to the definition, the imposition of coercive measures intended to prevent the third country nationals from leaving the border areas of the instrumentalizing third country in a direction other than through a member state. So you can see that it is a very broad definition, very vague in a sense that it doesn't actually, it will be something, the definition might be used according to the or as the member state country chooses to use it, and it might have very severe consequences for those seeking asylum. So the measures that are proposed in the regulations are very similar to those that were already proposed to Poland, Latvia, and Lithuania in this previous document that I already mentioned. So basically, what it might mean that when Poland is claiming that Belarus is instrumentalizing migrants, or what can actually Finland right now say about Russians, encouraging people to try to cross the border from Russia to Finland, it might mean that the member state will be able to close some of the border crossings and leave only some open for the applicants to apply for asylum. The registration periods for asylum applications will be longer than even in the border procedures. The material conditions will be reduced. The admissibility procedures will be conducted at the border in the time frame of up to 16 weeks. And obviously, this will lead to increased detention of those seeking entry to the European Union, and their guarantees when it comes to access to lawyer or any other assistance during the proceedings will be lowered. So to conclude, I will maybe send you a link to the impact assessment of the act that we conducted for the European Parliament in the team of other researchers as well. And our conclusion was that this particular regulation, first of all, will not serve its purpose. And this is because the whole issue of instrumentalization is definitely an issue of the foreign affairs, of the external policies of the EU, rather than EU asylum law. So those challenges that European Union is facing right now are to be addressed differently. The mechanism that might be introduced in situation of instrumentalization that, as I already said, lacks the clarity and might lead to very arbitrary derogation from the EU asylum law, might also further undermine the common asylum system. It also, like when you look at the vocabulary used in the document, it dehumanizes refugees, calling them a hybrid threat and using very military terminology rather than the terminology, associated with human rights or the international obligations. So what definitely this whole concept and this whole piece of legislation ignores is the current situation at the EU external border. And this study that I'm referring to right now is showing it very clearly. As long as we have serious human rights violations at the borders, with non-refoulement principle being violated, with rule of law crisis in many, states that are also the external borders of the EU, where the law just doesn't apply at the borders, where people are being brutally pushed back, basically, we cannot expect this new regulation to improve the situation. What it might does is to open the doors for further violations, especially where they're already taking place. And I think Poland here is a great example, because, like I'm saying, even in the peak of the humanitarian crisis at the border, when this legislation or the similar one was, put forward, Poland was still not very eager to implement it, seeing it as, the standard even higher than what was already happening at the border. So this is also one of the conclusions of the study. It just might not be effectively addressing those situations, but rather undermining the asylum system even more. Thank you. I will stop at that.
Thanks so much, Marta. And it's really good timing, because the report, which I can very much recommend, is also being presented in the Parliament tomorrow. And it will be really interesting to see how the debate goes, if people do choose to follow along, because there will be a discussion of whether or not MEPs will choose to open this regulation or just to reject it and vote it down. And this will make a huge impact on how things move forward. Moving on to some of the questions, we have just under 15 minutes, so maybe we can, luckily Minos has been doing a great job answering some of them in the chat, so if you can check, lots of them are already answered, which is very, very grateful for that, Minos. I did see some questions about other legislation, so I also just quickly wanted to say or highlight some things that Minos had written, that yes, this is the new pact at the moment, but there are also other things that are going to be implemented and recast in the coming years. Marta mentioned the Schengen Borders Code reform, which is also currently going through negotiations, and where also they had originally tried to put situations of instrumentalization. In the Parliament position, it was removed, but there's no guarantee that it won't be re-entered now through the negotiations. Additionally, when considering the asylum procedures regulation, it's important to consider that the returns directive is also currently going through a phase of being recast, and there are questions as to whether the suspensive effect of appeal for all return decisions will be retained. And I saw somebody asking about the facilitators package too. And as Minos answered, yes, this is a file that is set to be reopened in the next legislature after the parliamentary elections in June. And so we might see a redefinition of exemptions for humanitarian aid within the facilitators directive. So in all that we've been talking about here, the systems will change, but so will the systems for the people supporting people on the move. That being said, I do want to turn to some of the questions that are still open. I think the first one I will ask that I think is interesting maybe for Marta is how an instrumentalization assessment is made by a country. And then I think it would be interesting if maybe either of the lawyers could talk a bit to what are the next stages for implementing the pact, as that's something that has come up a few times in the questions. Thank you.
Well, so this is one of the problems with this regulation. It lacks clear definition of instrumentalization, and also it leaves it to the member state to decide actually when the instrumentalization takes place. And this is something that we've been hearing a lot recently. Hope already mentioned Greek-Turkey borders, Spain, Morocco, and now Belarus, EU. And what I see there is definitely, and I already also mentioned it, rather the problem with the externalization policies, foreign affairs, and the relations with those states, rather than asylum law that could address those. So this is also something leaving like the doors for further violations here.
And Minos or Eleonora, I wonder if you can jump in a bit on what are the next stages we face after these political deals are made into the implementation in member states. I also just want to start by caveating that it's also things are already moving into implementation. If you look at the 45 million euros that were granted by the Commission to Bulgaria this year, it's essentially to develop screening centres near the external borders. So we can already see that money is being poured into countries to create centres on deals that have not even been politically decided. But on that, I pass to the lawyers.
Minos, as you want. Well, very briefly, so if these proposals are adopted, then there will be a time span, so they will not be immediately implemented into member states. I'm not sure, so Minos, if you want to step in, how much time member states have in order to, well, before the regulation can be applied. What I think it's quite interesting from one of the question is, can we challenge those rules against maybe the charter? So this is what we will try to see, to assess. Definitely, I think there can be some fraction between some of the provisions and the obligations member states have under fundamental rights treaties and the charter. So yeah, we will have some work to do on this side, but we'll have to see. As someone was mentioning the agreement between Italy and Albania, and I replied, we'll have to see, because right now we don't really know how exactly that one will be implemented. So of course we will have to challenge, to go in front of courts. And I think courts will be quite an important actor in upholding fundamental rights. But yeah, we will need to work on that for sure.
I'll confuse you a bit, maybe to pick up a couple of steps before where Eleonora started, very eloquently on what happens once these things, as expected, get adopted. Hope mentioned the 7th of December as sort of a key date where legislatures are expected to basically strike a deal. Now, what this means, based on what we understand thus far, is that there will be what is called a political agreement between Council and European Parliament, not necessarily on a text per se, which means we won't have a final draft of legislation, just a broad political understanding of how the whole thing should work. It will then be left to the technical level of the same co-legislators to actually hash out all the details and turn that broad agreement into actual legislative text. And I think for all of us, but probably more specifically for people who, sort of are in touch with policymakers in Brussels, it's quite natural for this process to be extremely painstaking, and actually for those technical discussions to be extremely, extremely important ones. I think what that also tells us is that beyond the extremely damaging content that we've been discussing for the past hour and a half, we also have a very fundamental question of lawmaking, right? We have a European Commission that puts forward extremely hasty, in my view, poorly drafted legislation with no actual assessment of its impact on the ground. And at the moment, we have two legislators negotiating without an actual text. This, to me, as a precedent, is already extremely dangerous for the EU, not only for asylum, but way beyond.
Okay, I saw some other questions cropping up that I quickly like to address, and then I will pass on for the final question. So I just saw a few people asking about how this will disproportionately affect racialized migrants, and I think this is very important to say. I think the first very important thing to point out is in the screening regulation, there is a article that the Parliament are trying to delete, but we don't yet know whether this will work, which says that screening doesn't just happen at the border, but also happens in the territory of the member state, and that anyone who looks like a migrant essentially can be picked up and may be subject to screening procedures. And this will rely heavily on ethnic profiling. Another thing is with the Eurodac regulations, the caveats for facial recognition technology, as I mentioned, are riddled with racial bias. And generally, the digitalization of all of these procedures are full of racial biases. And this is yet another piece of legislation called the Artificial Intelligence Act, which is trying to protect fundamental rights, which is also set to be decided by the end of this year. And the safeguards around fundamental rights are very disappointing as it stands. So this will be another element in which racialized migrants through technology and just through profiling will also be disproportionately impacted. Just for the last minutes, there's been a few questions about how we might stop or bring legal challenges against the Pact. And as we're in the very final stages and these things are very difficult, it's a complicated question, but I'm wondering if anyone feels equipped to jump in on how we might legally challenge these things. Is there anything that can be done on a legal level? I think we're at a point where these reforms will go through, but maybe in the phase of implementation, there are areas for address. But for that, I hand back to the panel.
Well, I can start, and maybe then I can also answer some of the questions that that were in the chat. I'm trying to type right now. You were also asking about the Polish or like the domestic judgment. So I just wrote, and I can send you maybe a link later. There are so far around 15 judgments of the Polish domestic courts finding since mid-2021, so with the current crisis at the border, that pushbacks are unlawful, despite the whole context of the alleged instrumentalization of people by Belarusian authorities. And there are also even more cases pending before the European Court, and this is another question that somebody asked, when can we expect those judgments to be delivered? Probably soon, but you know what soon means with the European Court. I mean, it can be, few years, but soon in a sense that already around 20 of those cases have been communicated to the Polish government, and we are right now at the stage of corresponding with the Polish government on that. So hopefully the judgments will be soon, and this is definitely one of the ways, one of the litigation strategies that will be used by lawyers, I believe, in all European states after the new pact. So the European Court, obviously, the Court of Justice of the European Union, that might also answer some of the questions regarding the at least the proper interpretation of those provisions. But I also think, like, at least in case of Poland, that the national litigation here might be crucial. So obviously, I mean, like, it might take some time and it might take some effort, but I do believe that at least with those, clearly contrary to the, human rights obligations of all the member states' provisions, it might happen that eventually they will be found, in violation of the EU treaties. But yeah, that remains to be seen, I guess, and we'll need to wait for that at least few years.
Does anyone want to jump in very quickly with the remaining two? Yeah, go for it.
Sorry, I'll be super quick, just picking up on what Marta mentioned. I completely agree, and I think anything that refers to direct action to annul EU legislation is already a hugely complicated matter. What I also wanted to mention, just in terms of, again, the entire process, is that co-legislators have circumvented their own legal advice on the Pact. And this was namely the case for the Council, with a very powerful opinion of its own legal service, which raised all sorts of extremely poignant questions on these proposals, only to be completely disregarded.
Thank you very much. And yes, this is another very concerning aspect. Well, yeah, with that, I know that there's a lot more questions and probably we could all say a lot more, but I think it's important to wrap up there. We will be circulating an email with some of the links, some studies from the different people here for everyone who signed up to the webinar. We will also write a summary of these discussions, which we will then have translated into the relevant languages in countries of transit, countries of movement, and countries of stay. And we will publish all of that on our website so that people also can share this information as widely as possible. We also plan to share some visuals for people to share on their social medias. The most important thing we can do now in this moment is disrupt this narrative. This is not a good deal. This is moving towards the abolition of the right to asylum, and people need to know, and we need to not let it pass in silence. So we'll be following up with an email with all of that. Make some noise, share what you've learned with everyone you know, and thank you so much for coming. And thank you to all the speakers and to all the translators for all of that work too. Thanks, guys.